Thank you so much to the sponsors for inviting me to thank you to the ICRC for having me. It's a privilege and a thrill to be here in Israel. And I'm going to be talking about the privacy of cell phone data. And I'm going to be talking about the Apple versus FBI case and some of the context for it. And at the end, I'll talk about how the insufficiency of the legal protection of cell phone data, I think, is part of the panoply of issues that explain Apple's resistance to the FBI order. Okay, so in case you're not familiar with the case, although I think many people are, if not most people, in February, the magistrate judge in San Bernardino issued an order requiring Apple to assist the FBI in accessing the plain text of the cell phone contents of the San Bernardino shooter who murdered 14 people. He was at that time dead, and so couldn't give the password needed. And the interesting thing, it's important to remember, is that the FBI had lawful access to the phone's contents. The FBI had a search warrant, and they also had the consent of the owner of the phone, because the phone was owned by the county of San Bernardino. But they couldn't get the access to the contents of the phone because they were encrypted, and the FBI said that they were unable to break the encryption, so they got an order from a court that required Apple to assist. And the issue was mooted eventually after a bunch of back and forth in the courts where Apple filed a motion saying they wouldn't assist, and the government filed an order saying they had to assist, and Apple filed a reply. The issue was mooted in March, meaning it went away, because, as you probably know, the FBI found a way in to the contents on its own, a hacking way in. But the issue is not gone, it's not resolved, because we don't know the robustness of that solution. The government has said that that solution is only for that phone or that operating system, and so it's quite possible that this issue will come up again. And there's an ongoing struggle that I'm sure you know about in the United States as well as elsewhere about government access to encrypted phone contents, where, as opposed to the companies like Apple saying that they don't want the government to have that access, and that having that access would be an infringement on privacy and raise a host of other issues, which I will now discuss. So, there's a number of things that inspired Apple's resistance. One of them is technology. Apple said that it would be too difficult for them to crack the encryption. There was a lot of discussion in their papers that they filed that it would be burdensome, it would involve a lot of work. They subsequently, in their motion, said it would be, I think it was 4 engineers, and it would take them 2 weeks. So it wasn't actually, physically impossible, but it was something that if they came up with a fix, it would be very dangerous for them to have this fix, because that fix was something that then would be very much of a honeypot. It would be something that would be appealing to hackers to steal, and it would get out. They also said that once they made that fix, it would be something that would be asked for again and again by the US government, and very importantly, it would be asked for by other governments. So in that sense, it would be a dangerous precedent. And they also said that asking for this fix and sort of forcing the Apple engineers to make something they didn't want to make was something that should be considered beyond the court's power, and that if anyone was going to make Apple to do this fix, it should be Congress. Okay. Another reason that Apple resisted was that, and Apple kind of resisted this, but everybody knows it's true. Apple sees a market benefit in putting a distance between itself and law enforcement. And this is something you see in the United States. I don't know if people know that Microsoft just filed suit against the Department of Justice, claiming that they need to be able to reveal more surveillance orders because those are secret, and they want people to know about how much data the government is requesting. So because the safe harbor has gone down, everybody knows, in Europe as a result of the European Court of Human Rights order, the U.S. Companies see a value in putting a distance between themselves and government requests for data. And that's particularly true for cloud services, as the U.S. companies want to sell their services to foreign markets. They want to make it clear that when the U.S. government asks for information from private companies, those companies aren't going to just say yes. But as you see, that's cloud services, whereas this was device data. And then there's the philosophy. Tim Cook, the CEO of Apple, issued a couple of open letters and blogs in which he said, you know, Apple has this commitment to strong encryption. They have a commitment to user privacy. And that was a very strong statement by Apple. And part of the commitment to encryption comes from something I know we'll be talking about here very much, which is encryption is obviously key to protecting against hacking, which is, as we all know, gotten out of control. It's also key to protecting against requests from what we consider to be repressive regimes. And again, this is back to the point that, and I've talked to people about this, is a very serious concern on the part of U.S. companies. If they say yes to our government's request for information about users, then that sets a precedent which makes them have to say yes, or reduces their leverage to say no when governments that we consider oppressive, China, ask for information about their citizens. And from a privacy perspective, Apple says, we all know that the information stored on our phones is incredibly extensive. People store their entire lives on their phones, and so that must be private. Now again, one of the problems here is how much of a threat is there really to data on your phone as opposed to data in the cloud, right? And if you think about attacks, most of those attacks are going to be launched against network data and not device data. So I don't think that explains the entirety of the concern about device data. So my thought is that there's really a feeling in the United States, and I'm sure elsewhere, but I can speak to the United States the best, that the current law protecting actual information on the device is insufficient. And we did have a recent Supreme Court case called Riley versus California last year, in which the Supreme Court said that when law enforcement arrests someone and searches them incident to that arrest, they need to have a warrant or what's called an exigent circumstance to search the cell phone. And it was a big decision by the Supreme Court. And the Supreme Court recognized, again, as I said earlier, how much information is stored on the cell phone and how much privacy is implicated by that search. And it was a very welcome decision by privacy advocates. Interesting, the California Supreme Court had said that the phone, when it's stored, when the law enforcement searches you, the phone is just like a cigarette pack. And so there's a precedent that said if you're arrested and you have a pack of cigarettes on you, law enforcement can just grab the pack of cigarettes as they're searching you under this incident to arrest exception. And so what's the difference between a phone and a pack of cigarettes? They're similar shapes and similar size. Nobody smokes anymore, but it's true, believe me. And the Supreme Court said they're so different. The other thing that California Supreme Court said is just like a physical wallet, right? What's the difference? Phone, wallet. And the Supreme Court said it's so different. How can you possibly analogize a phone to a wallet? It's like a riding on a horse versus taking a trip to Mars is the difference. And so it was a great decision that recognized that cell phones are different, but it was limited, and it was limited because it's this one narrow context, namely searches incident to arrest, and it turns out that in practice it has limited application, because in practice, what happens is when law enforcement arrests people, they seize the phones until they get a warrant, and then they use forensic techniques that perhaps people are familiar with that download absolutely everything on the phone. So anything, and so in practice, Oops, did I go too far forward? Hold on. Yeah. So in practice, it actually hasn't had that much of an impact on the arrest context. And secondly, people are worried about situations beyond the arrest context. And for that, in that context, we've also found out about cell site simulators, which have been used in secret, and they're only now becoming more public. There's a recent decision in our courts that said that when law enforcement uses cell site simulators, they must get a warrant. But that's, I think, in the last couple of months, and it was a lower court decision. And what we found out is that law enforcement has been using cell site simulators in secret, subject to non-disclosure agreements with the company. The claim is that law enforcement claims it's using cell site simulators to find out where people are located. So cell site simulators, I'm sure people know, but for those who don't, act as fake towers. And so they intercept the information sent by your cell phone or received by your cell phone to the tower as though it were a tower. But it turns out cell site simulators, you might have heard of them as stingrays or IMSI catchers, are also capable of intercepting content. They're also capable of installing malware. They're capable of a host of things, and we don't know how much they've been used. So there's a lack of trust about law enforcement's ability to get information off cell phones because it's taken us a while to find out about these techniques and because they're used in secret. In addition, and this ties into what Susan was just talking about, under our legal system, anything that's non-content can be acquired with minimal oversight, and under our statutory law, really no remedy. And so under our law, we have DRAS information, which is dialing, routing, addressing, and signaling information. Because that's considered non-content, law enforcement can acquire that in real time under what we call a rubber stamp court order. And I was just giving a talk recently and someone said, rubber stamp, that's so denigrating and disrespectful. How dare you call that court order rubber stamp? But that's actually what the courts call them themselves, is rubber stamp. Because the statute says that that judges shall approve orders that are complete. So they can't even do an independent oversight to make sure that there's a good reason to ask for this information. As long as a law enforcement officer or prosecutor makes a complete application and says there's reason to believe this information is relevant, our judges must approve them. In addition, our courts have been wrestling for a while with the protection for location data from cell towers, and I've actually argued some of these cases in court as an amicus, friend of the court. And the courts are settling on the idea, because of the third-party rule that Susan's been discussing, that such data is available without a warrant. And we have a general problem with, let me see how much time I have. We have a general problem with all access to device data, whether it's cell phones or computers, which is we haven't figured out a way to minimize the data acquired or to particularize our warrants so that when law enforcement gets access to such data, it's generally, as I said in the device context, it's everything on the device. And when you go to a service provider, it tends to be, I want everything pertaining to this person across all of their accounts, across all of their services, forever. And we have a concern about journalist information. We have a concern about whistleblowers. This has been particularly of interest as we've been talking about Edward Snowden and the fact that apparently the NSA has a poor record with its whistleblowers. Our concerns are magnified exponentially as we consider the horrifying prospect of a Trump presidency. And of course, the NSA metadata program showed us that, again, law enforcement in secret was collecting all to from information and perhaps more of our phones when we made calls within, without, and again, within the United States, not to mention issues of foreign people's calls. And then my last point is that Congress, who I think rightfully needs to be involved in improving the privacy of our telephones with requiring lawful process, has been fairly ineffective. With the NSA metadata program, they moved the database to the providers, but otherwise didn't really meaningfully fix it. Congress has been completely unable to fix our Electronic Communications Privacy Act. I will distinguish that from the California approach, which was a big success, not because I was involved, but it was a big success, which I'd be happy to talk about in questions if you're interested or offline at lunch. But now my time is up, so thank you very much.